Hey everybody, I'm Jim Smith from Pacific Wealth, and you're listening to the Take 5 video series where we post 5 questions to local experts to help you make a successful financial transition to a life in New Zealand. Today I'm delighted to be talking with Julia Johnston from Johnston Law, and she's going to answer 5 key questions that US citizens need to consider when moving to New Zealand. Julia, thank you for joining us.
Hi Jim, thanks for having me.
So Julia, we're going to jump right in. So our first question is around tax. So it's not a subject that's renowned for being the most exciting, but obviously nonetheless is important to get right. Specifically for new migrants, what do you see as being the key issues to understand around tax?
Yeah, so good question. Hopefully it's not as unexciting as you might expect, but tax is a really key thing, and most importantly it is to understand tax residency and how that will affect you. Tax residency is an international concept, but every country has their own rules. Often they are similar, but they're not the same. In New Zealand, we have multiple tests. The first one is based on the days present in New Zealand, and it's very clear if you meet that test or not. Although I regularly see it calculated incorrectly due to people not understanding the way it is calculated in terms of the rolling 12-month period. Once the day count test is calculated, you will backdate your tax residency to the first date of presence. That often catches new migrants out, as they have generally come to New Zealand for an initial sort of recce trip or an opportunity to visit and work out where they might want to stay in New Zealand. So that's the first test, and the second test is far more complex, and it looks at whether you have a permanent place of abode. Now, if we simplify it down to its very draw it back to its easiest concept, it's whether you have a home. Now, that doesn't require you to own a property in New Zealand. As you may be aware, there are rules regarding migrants and ownership of properties, so this can be a rental. Obviously, staying at a hotel, this is not going to be a permanent place of abode if you are in transitory residence, but if you rent a property, that can be a permanent place of abode. Now you say, why is this important? Well, New Zealand tax residents are taxed on their worldwide income. So you can see why this is really, really vital for people to understand. Now, a lot of people will have the thought process that it doesn't matter, there is a double tax agreement or DTA. Yes, that's true. There are double tax agreements with most of our main trading partners, in particular the US, UK, but this doesn't alleviate tax in its entirety. It can assist though. Also, another thing I often hear is I've got a transitional tax residency or the temporary tax exemption. Now, again, that can be really, really, really beneficial. It's hugely important for new migrants to have that and understand it. The temporary tax exemption is a period of between 4 and 5 years where a new migrant or returning Kiwi can benefit from having their foreign passive income tax-free in New Zealand. Now, that's a really wide and all-encompassing benefit that is offered to the people, I call it a gift from the New Zealand government. It allows new migrants and returning Kiwis to have a period of time to restructure their assets and wealth, to consider how best they want to structure these things going forward. Now, one of the key things that people do not understand is the foreign passive income exemption does not apply to working for offshore employers or contracting overseas. So that is not covered by the temporary tax exemption, and it's really important that people are aware of that. Another key point is that your temporary tax exemption relies heavily on understanding your New Zealand tax residency status and when you met both of those two tests, and that will give you the end date for your transitional tax residency. So I think going back to your question of what is the key issues to understand, it's your New Zealand tax residency status and your status under both transitional and the double tax agreement, and it's understanding then how you will be taxed during that period, and then after that period, once you've ended your transitional tax residency exemption, it's understanding how your various assets outside of New Zealand, if you still have assets out there, are going to be taxed, and having an understanding that the double tax agreement does not mitigate tax in their entirety. So there are a lot of investments and forms of income that will still be subject to tax, and even if there isn't a double tax in terms of dollar figures, there's most certainly a filing requirement across both jurisdictions, or nearly always.
No, great. Thank you, Julia. So just staying with tax for a few more minutes, what do you see as being the key issues specifically for tax as it relates to investments and retirement planning?
Yeah, so good question, and it's something we're asked a lot. And I think that's having an understanding of how the FIF, or Foreign Investment Fund, rules apply from a New Zealand tax perspective, and then having a full and comprehensive understanding of how the equivalent rules apply to you in your home country. So I will use a US citizen as an example, and most US citizens are they're invested in the stock market via various investments such as their 401k, IRAs, etc. They're pretty standard for a US citizen in my experience. Now, if they were to keep a stock exchange listed portfolio over in the US, in New Zealand, that would be a foreign investment fund. The rules don't work well with the US tax system in that they don't completely cross credit. New Zealand does not tax on capital gains, as you may be aware, and we also don't choose to tax those dividends. What the FIF rules do is deem an income from the opening value as to one method, or deem an income across the various methods of the FIF rules that can apply even if there has been no income received. Now, this is a huge opportunity for people to consider how they're going to invest, because the FIF rules, while they don't necessarily correspond with what most US citizens are maybe used to, or citizens of other countries, there are huge opportunities here, because the default method is that it will be a 5% income, so 5% on the total value as an income, and then tax on that at the marginal rate. Now, if you have a portfolio that's geared up to receive dividends that maybe they're more than 5%, or you've got a dividend portfolio, that can be really beneficial. So the FIF rules are not necessarily bad, they're just different to what normal migrants migrants are used to in their home country. So therefore, I think that is really key for people to understand. And then if we look at retirement planning, it's also understanding how your retirement plan in your home country is going to be taxed in New Zealand, and having a consideration and a discussion with your financial advisor and your tax advisor from your home country alongside your New Zealand tax specialist to understand what your options are. Do you withdraw that pension fund from your home country? That may be subject to penalties for early withdrawal. It may be subject to tax in your home country. And is there an opportunity to bring it to New Zealand, maybe tax-free, to mitigate those taxes? Or what are the alternatives? Do you keep it there and do you set up a new investment in New Zealand? How will that be taxed to you if you have tax obligations ongoing in your previous country? So this is a huge area that we can provide assistance for clients. Recently had a consult which resulted in a client saving $175,000 of New Zealand tax, almost virtually following their plan that they had already set out, with a small amendment which saved them significant, obviously, dollar figures. So there are often multiple ways to achieve the same end result, but each way might have a slightly different tax implications. So it's really important to go on that journey with your tax advisors and your financial advisors so that you can get the best result for you and keep the most money in your pocket.
Great advice, Julia. Thank you. And it sounds like to me that context is key, and the right advice for one individual may be the wrong advice for somebody else. So it's important to get that personalised advice from different professionals.
Yeah, absolutely. What works for one person could be absolutely terrible from a tax perspective from another, and I'm sure the same applies to financial advice. Everyone's circumstances are different, and understanding the facts of the particular case is where you start, and you can't begin to make a plan until you understand all of the relevant information, and one small fact change can change the entire journey, and I'm sure that's the same with financial advice as well. So having your own advice is really important. Doing research is great, and reading online and speaking with other people, but nothing will replace personalised advice.
So Julia, for our third question, we're going to switch subjects to talk about asset protection, and New Zealand has a piece of legislation called the Property Relationships Act. At a high level, what do you see as being the implications for New Zealand's Property Relationships Act for new migrants?
Yeah, so this is often something that catches a lot of migrants out, because in New Zealand, our relationship property legislation deems a de facto relationship to have the same standing as marriage in nearly all circumstances. So a lot of couples I will speak to will potentially are not married and keep their finances quite separate, and that's completely up to them. However, should they separate once they have moved to New Zealand, if the New Zealand legislation applies to them, which most likely will if they are domiciled in New Zealand by that point, then their separation will be governed by that legislation. So the key point to note there is that there is a presumption of equal sharing. So if one partner has come to the relationship with significantly more assets than the other, or still has significantly more, and they run their finances quite separate, that may not be the case in a separation. So it's something I like to bring to the attention of new migrants to ensure that they have considered that, and if they are comfortable with keeping their assets separate, then maybe they should consider entering into a contracting out agreement or a prenup, which is what maybe the American clients might call it.
So just in terms of that contracting out agreement, can you provide a bit more context in terms of what that means for New Zealand residents?
Yeah, so a contracting out agreement, or prenup, as you might be more comfortable calling it, is a way that you can contract out of the New Zealand legislation. So that presumption of equal sharing is what applies if you haven't entered into a contracting out agreement. So if you wanted to keep, for example, a house as a one person's separate property, or certain investments as separate property, the contracting out agreement can allow the couple to do that. Now, there are very strict processes that apply in entering into a contracting out agreement. Both parties must have independent legal advice, so that's two separate lawyers and two separate firms. They need to be advised as to what they're giving up under the legislation before they can actually choose to make that step. Now, a contracting out agreement is a bespoke agreement. There's no copy-paste, very much like your tax and financial advice. You can actually take that as far or as narrow as you like. So some clients might just choose to, one asset is completely separate, that's a family home that needs to be kept separate, or it could be that everything is separate, including income, and we keep things completely separate financially. And each couple will have their own preferences as to how far on that continuum they would like to go, and also it needs to be something that both parties in the relationship agree to. But it does allow the couples to effectively contract out of the legislation, so that if they were to ever split up, it is very clear which each individual keeps in the separation.
Great. So moving on now to estate planning, what's your advice to new migrants in regards to their wills?
Yeah, that's a good question, and something I think that's really commonly overlooked, because it's one of those things that people might do. They form a will, and then they hopefully forget about it for quite some time. However, people that are domiciled and living in New Zealand would they certainly benefit from having a New Zealand will. Now, you can generally seek probate of a foreign will in New Zealand, so you don't have to, but it is very expensive and time consuming. The best option is to enter into a New Zealand will for New Zealand couples, and that New Zealand will should cover your assets other than real property that may be overseas. So, for example, if you are a British couple that still own a home in the UK, then we would potentially look at creating a will for you in New Zealand, which covers your worldwide assets, except for that property still located in the UK. This is something that we work with our clients on, one, to ensure the ease at a very difficult time when someone passes away, to ensure that you can have a New Zealand probated will. And we often work on the will alongside the tax advice that we're providing, so that we can ensure there is tax efficiency. It's often something that we will work with alongside a home country tax advisor if there are risks of having tax back home as well, and that will be particularly so for US citizens.
No, great. So can you explain to us what is meant by an enduring power of attorney in New Zealand, and whether it's a good idea to have one?
Yeah, so an enduring power of attorney is not something special for migrants. Everybody in New Zealand should really have one. So this is a key document. It's actually two documents that allows you to give someone or multiple people the ability to make decisions for you should you become incapacitated. So there is one power of attorney is an enduring power of attorney in respect of personal care and well-being. That is for decisions in relation to you and your care. The other one is in relation to property, so that's all your things, your assets. Now, there are certain rules about who can act, whether it can be one person or two persons, but basically the idea of the document is that if you become incapacitated for any reason, there is someone that can make those decisions. Without that without that power of attorney document, someone would have to apply to the court for a grant so that someone can be named to act in that capacity. That becomes expensive, very time-consuming and extremely stressful in what is obviously already a stressful situation. Key examples of when the enduring powers of attorney can kick in is obviously in the case of mental incapacity, such as dementia and Alzheimer's, but also in the case of an accident or illness, injury. I was working with a client on a separation, and I always mention that it is important to have a new power of attorney and will if they want to remove their ex from having those rights in their wills and powers of attorney. And the client decided to wait. We had this discussion on a Thursday. He said, no, I'm not going to do it right now. He didn't actually have a power of attorney in place at all. He then was involved in an accident over the weekend, which had him left in a coma. He'd entered into an agreement to purchase a property, and while he was in a coma, he found out, his family found out he was being sued by multiple parties because he could not complete the property transaction because there was no power of attorney in place to sign any documents in relation to the purchase. That's obviously an extreme example, but it is an example of the situation where a power of attorney would have really assisted.
Yeah, it does seem like quite an unfortunate person, but obviously, as you say, it really highlights the value of getting these things in place when you're able to.
Yeah, absolutely.
Julia is the founder and director of Johnston Law, a New Zealand-based tax practice. They specialise in offering expert tax advice on the implications of relocating to New Zealand and how to structure assets for tax efficiency. Their specialist guidance extends to assisting clients with various issues related to relationship property and asset protection. To book a no-obligation initial discussion with Julia, please go to her website www.johnstonlaw.nz. Julia, thanks very much for joining us on this Take 5 video series.
Thanks for having me, Jim. It's been a pleasure.